So let us begin with part 9 of the Indian Constitution, which is the Panchayats. Okay, for rural areas we have the Panchayat, for urban areas we have the municipalities. Now Panchayat is mentioned in part 9 of the Indian Constitution, and municipalities is mentioned in part 9A of the Indian Constitution. Okay, now part 9, the Panchayats, they cover Article 243. Earlier the Union Territories, the articles covered were 239 to 242. Now next comes 243, all the way up till 243O. And then the municipalities were covered after O. Which letter comes after O? P. P to ZG. Okay. Now let's begin with part 9 of the Indian Constitution, the Panchayats. What is Panchayati Raj? It is a traditional village self-government that existed before independence. Before independence, Gandhi said that India is a collection of little republics. Okay, little republics. So traditional self-government existed before independence in India. Now, one very important point to note: we do not have a Panchayati Raj system in Nagaland. We have the village council system. Okay, we derive our powers directly from Article 371A. We do not have a Panchayati system. The Panchayati system exists even in Assam, in our neighboring states, but not in Nagaland. We do not have Panchayati Raj. So whatever you're studying something that exists outside of Nagaland when it comes to Panchayat. But municipalities, we have a municipal council, Dimapur Municipal Council, Kohima Municipal Council, and Mokchung Municipal Council. These are the three municipal councils. Rest of the district, the rest of the district, town council. Okay, town council. So, and then the smaller, the village council. Municipal council, town council, village council. We have these three tiers, okay, of rural governance. What is Panchayati Raj? Traditional village self-government existed before independence. Charles Metcalfe called villages little republics. Gandhi advocated Gram Swaraj, independence of Gram, village. Okay, initially covered under Article 40, it wasn't given a constitutional status before 1992. Okay, before 1992, it was simply a DPSP, Directive Principle of State Policy. These are policy guidelines to the states, right? Like I said, it's an encouragement to the state on how to govern the country, DPSP. So it was only part of the DPSP, Article 40. And Panchayati Raj was given a constitutional status by the 73rd Constitutional Amendment Act 1992. So it became effective from 24 April 1930. So we had the ancient Panchayats, and after independence, it was part of Article 40 of DPSP, and with the 73rd Amendment, it was given a constitutional status, and with the 34th Amendment, they included Part 9 of the Indian Constitution. Is that clear? Now, 73rd Constitutional Amendment Act 1992. It added Part 9 to the Indian Constitution. The 73rd Constitutional Amendment Act of 1992 added Part 9 to the Indian Constitution. And within that Part 9, there's Article 243 to 243O. It also added 11 schedules with 29 subjects. How many schedules do we have in India? We have 12. Okay, we have 12 schedules. The 11th schedule is Panchayat. The 12th schedule is municipalities. Now, what are schedules? These are just some important lists mentioned at the back of the Indian Constitution to make it convenient for the Supreme Court, for the central government to read. Okay, the schedules, it has no specific reason as to why it is termed schedule. It's just an additional list at the back of the book, at the back of the Constitution. Okay, so it's the 11th schedule with 29 subjects. If we were to include all the 29 subjects within the Indian Constitution, main Indian Constitution, it would be too bulky. So they gave the constitutional right in the Constitution, and once they gave the constitutional right to the Panchayati Raj, its powers and functions were mentioned in the 11th schedule. Okay, outside of the main articles. So it granted constitutional status, and it is based mainly on LM Singhvi committee recommendation. Which committee is primarily responsible for the creation of Panchayati Raj as a permanent institution? The answer is LM Singhvi committee. Okay, this is the answer. Now, basic structure of Panchayati Raj: district level de Zilla Parishad, intermediate level de Panchayati Samiti, village level de Gram Panchayat. If you look at it, village Bosti de do Gram Panchayat thakibo. Okay, it is called Gram Panchayat. Village council nishna is equivalent to Gram Panchayat. Intermediate level Panchayat Samiti. We do not have an intermediate level. We just have village, the district. District level, we have the town council. They have the Zilla Parishad. Okay, and states with population below 20 lakh may not have intermediate tier. Now, what's the population of Nagaland according to 2011 census? The population of Nagaland is 19 lakh something. Okay, 19 point something lakhs, less than 20 lakhs population. But that necessarily isn't the reason why we do not have an intermediate level. Since for us, Article 371A, okay, we could have, but we don't. District level, Zilla Parishad; village level, Gram Panchayat; and intermediate Panchayat Samiti. This is the basic structure of the Panchayati Raj. Now, Gram Sabha versus Gram Panchayat. That's the difference. Everyone gets confused. The Gram Sabha, Gram Panchayat. Panchayat is the actual council, okay? Whereas Gram Sabha, all the registered voters of the village is the Gram Sabha, and then the Gram Sabha is the body chosen by the Gram Sabha. Okay, the Gram Sabha will choose the Gram Panchayat. They will form a Panchayat, and all the registered voters, all the members of the village above 18 years of age are considered registered voters of the village for the creation of Gram Panchayat. Even for village council, okay, that should actually be the case, but what we do is that clan is up to turn by turn kure, this and that. VDP secretary be turn by turn kure. Nah? No voting system, no democracy, nothing. But in the actual rule book, all registered voters of the village will vote for the Gram Panchayat. Okay? The Gram Sabha permanent body, because human beings will always continue to exist, and Gram Panchayat are directly elected members. Gram Sabha is the foundation of Panchayati Raj, and the Gram Panchayat, it implements development programs. Okay, who is the head of the Gram Panchayat? The Sarpanch, or some people call it Pradhan. Okay, the head of the Gram Panchayat is the Sarpanch. Now next we have Article 243 to 243G. Okay, we will study about all that. Now 243A, it contains the definition of Gram Panchayat and so forth. We studied about 243A, the Gram Sabha, and 243B, it talks about the three-tier system which I mentioned earlier, and 243C, the composition and elections, which we will learn in the next slide, and 243D talks about reservations and so forth. Now let's begin with 243C, since we are already done with 243, 243A, and 243B. Now 243C contains the composition and elections. We'll focus on the elections. In 243C, it mentions the method of election to the Panchayat. Direct election, okay, direct election, they are directly voted upon, and uniform representation across seats. Uniform representation across seats, composition determined by state legislature. And if you look at it, local government, it is directly under the control of the state government, not the union government. Okay, it is the state government that make rules for local government, including even municipal councils and municipal corporation. Everything is under the control of the state government. Now, Article 243D talks about reservation. There's ST, SC reservation according to the proportion of the population, and minimum 33% seats for women, and rotation of reserved seats, and states may reserve for OPC. So let's look at the first point here. SC, ST reservation population proportion. population la proportion ko ase, which means, for example, there's 100 seats. Okay, there's 100 seats, and then the percentage of ST in that particular state is 20%. Okay, 20%. Then ST will receive 20% of the seats, since the population is 20%. So 20% of 100 seats is 20 seats. 20 seats will be reserved for them. Okay, it is always according to population, and minimum 33% seats for women. That's like percentage wise. So kiman seat haigilibi udula 33% do reservation for women rakhi diye. And then rotation of reserved seats. For example, 33% women reservation de itia bi mohalla municipal election de kunba jaga de kunba ward de maiki gani reserve kori de. So next day do alag ward te jabo. So rotate court haibo. Okay, alag constituency, alag ward, every ward there will be rotation of reserved seats. So if the seats were reserved for ward A, B, and C, next it will be reserved for for ward D, E, and F. In a type rotation thagibole. So states may reserve for OPC. Now other backward caste, okay, OPC karne do state law opode ase. Some states they reserve, some states they don't. Okay, but there is a very important rule mentioned by the Supreme Court that any kind of reservation in any part of the country should not exceed 50%. So just imagine that 33% seats women reservation as a, let's consider one state, okay, and the other 33% seat DDC. How many percentage pachi as a 17%, right? So the 17%, let's say ST la population the 20% above the as a, to tan give around 26 DDC. To OPC karne na paje do. So in la situation de OPC ke reservation diyo na pre. Total reservation should always be less than 50. In Nagaland we have 42%, right, including the PWD and so forth. The Eastern they have 25% reservation. So it should always be less than 50%. That's the mandate given by the Supreme Court. Okay, so this just an illustrative split. Women 33% reservation, SC ST proportionate, let's say is 10%, total 43. Now OPC kan karne 7% diyo paribo, or general karne 50% diyo paribo. Okay, that's how reservation works. Every kind of reservation, it should never be above 50%. Now we have Article 243 EHIK. Okay. In Article 243E, we have the duration, Panchayat 5-year term as a election before expiry, before the 5-year term expires, fresh election within 6 months of dissolution. In case the Panchayat was dissolved before the end of its term, then election must be held within 6 months. Okay, but there's another condition. If the dissolution happened just less than 6 months before its original 5-year term ends, election is not necessary. Let's say 5 years, the 3 mahina 5-year term complete the election necessary no. So that's one rule. And then Article 243H, we have the finance of the Panchayats. The Panchayats may levy taxes, duties, tolls, and fees, receive grants in aid from the state. From the state, not the union, from the state, which means state can be subsidized, or whatever taxes are collected, center control it is a state that receives it, or it is a state that gives grant in aid to the Panchayats. Now we have the VDP secretary. All the village councils, they receive grant in aid from the state. Okay, every year they receive grant in aid. Depends, varies from population to population, council to council party receive grant in aid. Or you don't have VDP secretary village development board under the village council, and then the secretary is the one that handles the funds. VDP secretary. The VDP secretary don't know grant in aid tai July gina tai income maru and all that. Okay. So now we have the State Finance Commission. The State Finance Commission is a commission that's constituted every 5 years. Every 5 years, the governor will appoint a State Finance Commission to review the financial position of Panchayats. Finance Commission every 5 years Natun Finance Commission panawo, uto Finance Commission bra review gruwa the financial position of the panchayats and tahan ba recommend gruwa. Next 5 year de aro kiman credit net diwo, kiman budget diwo, na all that. And in Article 243K, we have the State Election Commission. State Election Commission. Election Commission of India and State Election Commission. These are two commissions that are very confusing, okay? The Election Commission of India, it handles elections of Rajya Sabha, Lok Sabha, Legislative Assembly, Legislative Council. Okay, MLA or MPs kanda pura Election Commission of India. But Municipal Council, Town Council, Village Council nishna, Panchayati Raj, Panchayati Samiti, Zilla Parishad, and Municipal Council Corporation, all these are controlled by State Election Commission. Okay, so whatever election we had, the Municipal Council, ward councillors kan ulaishe. Now we have Huketo, who is the chairperson of the Dimapur Municipal Council. All these 23 wards election law damde kunra conduct krushe State Election Commission. Aru the State Election Commission to kunra appoint kore state government. Okay, so anything related to rural governance, state government kore. Now, Election Commission of India has no say, has no power in matters related to election, transfer and posting, whatever rules and regulations of the rural government. Okay, very important distinction. So, the state will create the State Election Commission, which will supervise, direct, and conduct panchayati elections. Is that clear? Now, we have Article 243L. M and O. Okay, that's the last article. Now, Article 243L talks about application to union territories. The application of Panchayati Raj to union territories. It is possible for Panchayati Raj to be extended to union territory, but it is solely in the hands of the President. Okay, the President may direct with modifications the application of Part 9 to any union territory. So that's the only thing you need to know. Panchayati Raj, if there's a Panchayati Raj in a union territory, it means the President has approved that, and if there's any modification, it is done by the President, okay, not by the state. In the state, kun kore, the state government. In the union territory, the President, okay. Do not forget that. Article 243M, areas excluded. Part 9 does not apply to scheduled areas, tribal areas, and specified regions. Now, you will find the 5th schedule and the 6th schedule. We will discuss about that later. It doesn't apply to scheduled areas, tribal areas, and specified regions. Now they enacted the PESA Act later on. Okay, a Panchayati extension to scheduled areas. After that, with the scheduled areas, the Panchayati Raj to extend kurishe. We will learn about that later as well. So, but this in particular, Part 9 does not apply to scheduled areas, tribal areas, and specified regions. Tribal areas, Nagaland is also one of them. So in places where there are special articles, Manipur, we have Article 371C, they have C, and then we have Article 371A, right? And different tribal councils, even in Tripura, they have their own tribal council. And in those areas, Panchayati Raj will not be applied. That's the only rule. Our kun jaga apply kore nokore, yet they will discuss about it in the following slides. Now we have Article 243O. Bar due indifference by courts. The courts cannot interfere in electoral matters except through an election petition. Now what this means is that anything related to matters of election, municipal council election kurese, state election commission bana, election conduct kurese. The way in which the state election commission conducts election, if there's any problem whatsoever, kiki issue will be court chao na pare during election. Only after the election, an election petition can be submitted to the court, and then the court can take upon the case and then review and check. But during election, court takpi iku corona pro. So that's a very special power. Okay. Now these are the responsibilities. These are the subjects, 29 subjects assigned to panchayats. Please take a look at it for some time. Man, but what are the things that are missing here? some of the subjects. Do we have law and order? We do not have law and order. We do not have police, I think. We do not have police forces. And we also do not have land revenue, I think. Yeah. We also do not have highways, national highways. So Panchayats, they only manage road highways. I think road highways is mentioned there, right? So yes, roads, culverts, bridges, ferries, and waterways. Okay. Point number 13. So these are only for posti laga rasta khan karne ase. But highways, taan ke power dingina nai. So sub subject to nai. But posti karne ki apply karo udan pura digina ase. These are the 29 subjects. Now, do you guys want to memorize it? Up to you. Okay, moi don't know kore. Aro kide bi no kuro. I just know 5 to 6 subjects which I use in my mains examination. But 29 subjects udu do excel purili bi pauri jawle ase. So sometimes we have to accept the futility of human ego and understand that it is not worth our time memorizing. So I don't memorize. I just memorize 5 to 6 points, very easy ones, and then I use that in my mains examination. So you can do the same, or you can go and try to memorize everything. Now this is the historical evolution. We studied all the articles of the Panchayats, right? Now let's look at the historical evolution. In ancient times, they had village republics. Okay, they had little republics, right? There was this head of the village, Gramin. They call it Gramin in the ancient. You will read about that in Indian history. In ancient India, they had village panchayats. Okay, and then in 1882, Lord Ripon was the first to establish local self-government. Okay. Method of election was very indirect. It wasn't direct, but local self-government going on, they introduced Krusha, wherein the head of the villages will report to him. Okay, so that was the plan made by Lord Ripon. So the idea of a panchayat, the idea of local self-government was first introduced in India by the following Lord Ripon. Okay, that's the answer. Although I think it came twice in our NPC preliminary examination. So this is a very important point. And in 1952, the Indian government introduced the CTP, Community Development Program. Okay, in 1952, it did not have Panchayati Raj. Now it failed terribly. Okay, Community Development Program was introduced to uplift the rural communities, to bring development and progress to rural areas, but it failed terribly. Like iman biar ba fail huise. Now they constituted a commission, Balwan Rai Mehta Commission, to check what is wrong. Kile India do progress na thake. And Balwan Rai Mehta Committee in 1957 directly mentions in its recommendations that it is the absence of local self-government. The ekta governing system ekta thakiwa lage posti de. Law and order thakiwa lage. Ekta proper plan strategy kura laga ekta thakiwa lage. Koigina Balwan Rai Mehta ra kurise. Okay, and which is why after the Balwan Rai Mehta committee recommended that, officially India said that Panchayati Raj institutions can be instituted accordingly in various states. So they issued the notification, but the catch is that the institution of Panchayati Raj was optional. Kunba khulio parbo, kunba khulio na parbo. Now in 1959, based on the recommendation of the Balwan Rai Mehta committee, inspired by that committee's recommendation, the government issued a notification, and from that notification, Rajasthan was the first state to establish Panchayati Raj. Okay, they asked that last year in the preliminary examination. Rajasthan was the first state to introduce the Panchayati Raj system in 1959. Okay, but one is not optional thakise na. And 1977 de Ashok Mehta, even he recommended. Now 1957 Balwan Rai Mehta de the 3-tier last system thakise de. 3-tier Panchayati Raj system, and in 1977 2-tier. Now what do we have? Which version do we have now? We have the 2-tier. Okay, the Panchayat and the municipality. Okay, now in 1989 64th Amendment Bill, here in 1989 64th Amendment Bill was the first time that it actually brought the idea of Panchayati Raj to a parliamentary level very seriously, and as a result of which, in 1992, the 73rd Amendment gave the Panchayati Raj the constitutional status. Okay, so just for your understanding, you don't need to, know everything in detail. So two committees related to Panchayati Raj, Ashok Mehta and Balram Mehta. This question no I again. Okay, in the match the following week I work, or which committee is related to Panchayati Raj koina. Alag committee, Sarkaria Commission, Fazal Ali Commission, Balram Mehta Commission. The answer to Balram Mehta Commission. Okay, these are the two committees related to Panchayati Raj. Now, I initially mentioned in the earlier articles that the Panchayati Raj does not apply to scheduled areas and tribal areas. Right? I mentioned about that. Now, after which, in 1996, 1992 day, 73rd Amendment day, Panchayati Raj ke constitutional status dishe. Tate mention kori kina ase gi scheduled areas te extension na thakibo Panchayati Raj to. But 4 years later, 1996 day, PESA, okay, Panchayat Extension to Scheduled Areas Act, 1996, okay, it applies to 5th scheduled areas, only 5th scheduled areas. There are 10 states. There are 10 states that are part of the 5th scheduled areas. Go to 10 states there. Nagaland, Meghalaya, Mizoram, Uton, Naide. Any outside of Northeast India, as the 10 states, so na with scheduled tribes and so forth. Thagyat area kange every state there chutu as. Now it applies to 5th scheduled areas. It protects tribal self-government. The Gram Sabha controls minor forest produce. Local resource management vested in villages. These are some important functions. The PESA Act 1996 applies to 5th scheduled areas. That's the only thing you need to remember, okay? The Panchayat was extended to 5th scheduled areas by the PESA Act of 1996. Now the position of Northeast right now, even the PESA Act or earlier, it does not apply to Nagaland, Meghalaya and Mizoram. Okay, Nagaland, Meghalaya, Mizoram, 9. And then 6 scheduled areas. 6 scheduled areas, Assam, Meghalaya, Tripura and Mizoram. Assam, Meghalaya, Tripura and Mizoram. Okay, to the charta though, 6 scheduled areas as a. It does not apply to 6 scheduled areas. Hill areas of Manipur. Now what is 6 scheduled areas? Scheduled areas with a tribal population that has its own autonomous council is considered 6 scheduled areas. Okay. Now these 4 states are under the 6 scheduled area: Assam, Meghalaya, Tripura, and Mizoram. Even Manipur is seeking to be included in the 6th schedule. There are lots of issues. Okay, lots of issues. Even Arunachal is demanding. There's benefits to being part of the 6th schedule, being part of the 5th schedule. Why not hill areas of Manipur? Okay, so hill areas of Manipur, it doesn't apply to hill areas of Manipur as well. Even the hill areas of Manipur is governed under Article 371C, Nagaland under 371A, Meghalaya and Mizoram 6th schedule, part of the 6th schedule. Okay, so these are not part of the Panchayati Raj system. It applies, however, with exceptions to Assam, Arunachal, Tripura, and Sikkim. With the charter de Panchayati Raj ase. Panchayati Raj ase kunba area de. Okay. Now in Assam de ki ase almost sob jaga de ase Panchayati Raj. But places where there is autonomous council given by the 6th schedule. Okay. We have the Karbi Anglong. Karbi Khanbi ase na tambi 6th schedule under the autonomous district council ase tanla. So Utu district council kan thaga jaga de na thagiwo, but the rest of Assam they have Panchayati Raj. And then the valley areas of Manipur, hill areas of Manipur do protected, okay, under Article 371C. Valley areas kan do majority kan thaga jaga ase Meitei kan. To tate do Panchayati Raj ase. Okay, so these are man janule nalage, but just to give you a background of how it is in Northeast India. It's a little confusing, but later on you will learn. Once we study the 5th schedule, the 6th schedule, and everything, you will learn more in detail about that. Now, Lok Adalat versus Nyaya Panchayat. Lok Adalat or Nyaya Panchayat. Now, Lok Adalat, it's very confusing. Even if you research for like 100 days, okay, Lok Adalat is very confusing. It's still confusing. Kili gulido Lok Adalat to, it's just an act, okay, that gives power to, the judicial people to form a kind of alternative dispute resolution. A temporary court create power diala ude as be Lok Adalat to. So now let's talk about Nyaya Panchayat. Nyaya Panchayat to village council nisna ase. Village council debi ekta adjudicate kurole cases kan adjudicate kurole ekta group form kore udu nisna ase. Nyaya Panchayat to village level court ase. So for petty civil and criminal cases chitu mudu cases karne posti de handle kurole Nyaya Panchayat form kore. Lawyers generally allow no kore the panchayat bithor de generally lawyers kan tan allow no kore tan la custom tan la practices tan la understanding is that the punishment is given, okay, aur tan fine be impose koro pare but tan imprisonment de award koro na pare. Nyaya Panchayat se imprisonment award koro na pare to posti laga court to utu ase, okay, posti laga court to utu ase. Now Lok Adalat tan la basis to power to Legal Services Authorities Act 1987 by Lok Adalat Khulishe. It's an alternative dispute resolution. Now, you might think we have the Supreme Court, we have the High Court, we have the District Court, we have a lot of courts, right? Family Court, POSCO Court. Now, again, why Lok Adalat? Argue Lok Adalat. Now, Lok Adalat to, it's very interesting, okay? Fee bhi nalage, court fee bhi. Eko nalage. Sometimes the High Court, Kohima Bench High Court will organize a kind of ini ekta health camp nisna thake na, doctors can be free health care kan diwole itu nisna ekta camp organize kori de yadi aigina do cases can settle go parbo. Now the special thing about Lok Adalat is that there doesn't need to be right or wrong. Who is right, who is wrong udu no. It's all about negotiation, okay. Bitor de jabo or informally negotiate kuro. For example, apni la friend la ba 1 crore loi lise to usually court charge 1 crore pay to do. Lok Adalat do, it combines rationality and morality. Tai puibo Lok Adalat puibo, the judge will sit ar koi dibo a tai chor gurse 1 crore apni la hulibi tai bi tuksuk mano ase na tai bi jani na do korado noi jani na kurigina chor gurse gure do ekta khotha hulibi unintentionally tai bi aru to 1 crore tai paisa khado 10 lakhs se khaise to all of maaf kuri dibi tai ge ni 50 lakhs tak to return kori dibi na ekta negotiation. Court charge there's always a winner and a loser. Lok Adalat it's a negotiating table, okay. It negotiate kore to tam choli camp set up kuro jaga de, and then they'll try to solve cases through negotiations. Tuita party bi khushi paule ingala Lok Adalat ase. Now a very surprising thing is that decision do final award ase to Lok Adalat ki decision loise appeal down upper Supreme Court, High Court TV. Keep the negotiate korala samana. So it's a win-win for both the parties. So Kali Lok Adalat laga case ekla, we cannot appeal. District Court TV loi down upper, High Court TV loi down upper, Supreme Court TV loi down upper. Its decision is final. Okay, so I hope you guys will remember that Lok Adalat. Now, these are temporary camps set up by Supreme Court, High Court, and so forth. Temporary camps as a Lok Adalat. Okay, they for certain states, tan permanently Lok Adalat be create kore offices there. But pisibak to temporary as a alternative dispute resolution gonna define guru exam time there. Alternative dispute resolution, no court fee. The decision is final. No appeals can be made. Very interesting, right? Lok Adalat. Now.